Good afternoon. I'm very pleased to be back in Athens to work with you again. And my aim today is to take a legal psychology perspective on why sexually abused children are difficult from a legal perspective. And what I mean by that is that often the police, lawyers, and judges don't feel that the testimony from a child provides evidence beyond all reasonable doubt to convict an alleged offender. And I want to look at some of the mechanisms by which we can improve the conviction rate of sex offenders by treating children differently in the legal system. You've heard from the previous speakers about the zero tolerance, and we know from the World Health Organization about the 1 in 5, which is the estimated rate of contact sexual abuse. However, the first thing I want to add to that is that is the slides moving on that? Are the slides moving on the screen, or do I have to hit this? I have to hit this, right. What one is, it should be relative risk of child maltreatment on there at the present moment. It's only moving this. How do I?
Because it's... Δεν πηγαίνουν, ναι.
It's not moving. Technical problems. What do I hit? We're good. Yeah. Okay, we've got it working. Synchronized. So this is the slide I wanted to draw your attention to. That although the rate quoted is 1 in 5 children seem to suffer, most of them in silence, contact sexual abuse, that rate is very different for all forms of abuse, physical, sexual, and other forms, for children who have disabilities. And that children with learning disabilities, children with behavioural disorders are likely to suffer much higher rates of both physical and sexual abuse. This is not only by adults, but also by peers. We also know that children who are placed in institutions, and of course if you're disabled you're more likely to be placed in an institution, are 3 times more likely to be sexually abused than children in the community. So although NGOs like Smile as the Child think they're protecting children, when they take them away from communities to protect them and then place them in large children's homes, then the children are actually going from the frying pan into the fire. They are 3 times more likely to be abused in an institution and a children's home than they are if they were left in the community. And this is because not only do some adults who have not been screened properly for police records assault them, but more often it's their older peers and other children who've suffered abuse themselves in the institution that assault them. It's much more common for peers to assault them in institutions than the actual staff or adults. And this is a point that David Finkelhor pointed out earlier. So we need to think again how we intervene. Foster care is a much safer environment for sexually abused children as long as the foster carers are screened and appropriately assessed. The rate of foster care abuse of children in the UK is no higher than for biological parents. So it does happen, but it's rare. And that's much less opportunity and much less chance of that child being assaulted than if placed in institutional care. A very important point. The facts about child sexual abuse we've heard, so we can skip through that, about most of it, the children actually knowing their offender, and rather than children not knowing their offender. We also have heard that boys as well as girls are equally at risk up to the age of puberty, and it's only after puberty that girls are 3 times more at risk than boys. In the UK, only 1 in 10 children who are sexually abused ever get to the point where it is recognised, and so the police or social services or teachers miss 9 out of 10 children that are suffering child sexual abuse, mainly because the child doesn't say anything to anyone. And this leads to a very low rate of sexual abuse in comparison to other forms of child abuse on child protection registers, with neglect being the highest. We've talked about barriers to reporting from the child's perspective, but also there are barriers to reporting from the professional perspective. A GP or a professional in a hospital in A&E that might suspect something is wrong when a 13-year-old is presenting with a sexually transmitted disease would rather ignore the fact than fill in a paperwork that accuses child sexual abuse occurring, because that will tie that medical doctor up in paperwork for months if it goes to the prosecutor or to court. The doctor will get no time off from his clinical work because of the evidence he has to give to court. He'll get no more pay. So the bias is against turning a blind eye, not to get involved. And that is the problem from a professional perspective. From the child's perspective, we've already heard from David Finkelhor and others about why children don't disclose. We've actually known this fact since a study in Australia in 1985. It is now 30 years on since we've known why children don't disclose. Yet we're doing very little about changing that. We know that family is an important aspect in Greece, more so than other parts of Europe. So a child will be very unlikely to disclose and upset the family security that she has as a result of child sexual abuse. What advantages are there for the child to tell? She will be removed from the family. Rarely in the Balkans is the offender, well, rarely in Europe is the offender ever removed from the home. It's always the child. So the first thing we do to the victim is we punish the victim for telling us. We remove the child from their parents, from their brothers and sisters, and we leave the offender in the home on bail while he's investigated, instead of removing the offender. So why would we expect a child to tell us anything? So the child keeps it a secret. We need legislation to remove offenders, not children. The other thing that happens in court is the child is blamed for being sexually assaulted by peers or by friends or by neighbours. Her skirt is too short, or she wears tight blouses, or she was in a bikini just coming back from the beach. There's a very important, or she had drunk too much. There's an extremely important principle in law that the behavior of the victim has no bearing on the offense. A woman and a child can walk down the road naked, and they should not expect it to be assaulted as a result. This is not an excuse in the court system. We cannot say that this man hasn't sexually offended against this woman because he was drunk or she was drunk. There's now a law enshrined in the UK Sex Offences Act in 2003 that says you can no longer ask a woman's consent after she's under the influence of alcohol or drugs. You must only ask her consent when she's sober, prior to drinking. If you commit a sexual act with a woman that's had too much to drink in the UK and she complains afterwards, you can be done for rape because you didn't ask her consent when she was sober. That law is very controversial but needs to be considered in other countries. Another thing that comes up about children who make allegations of sexual abuse is people claim they're false. And this is especially a way of earning money as an expert witness and as a lawyer in North America, where you try and prove that the testimony of the child is false. Now, it's true that where the allegation originates from an adult, and that adult is in a custody or divorce proceedings, it's very true that at least half allegations are false. But the important piece of that story is that the allegation originated from an adult, not the child. Where an allegation originates from a child, there's very little chance that it's a false allegation. And studies have begun, studies in the 70s, studies in the 80s, we've known this for over 30 or 40 years, have shown that only about 1% of children ever make a false allegation. And that might rise to 6% for teenagers and adolescents. Nevertheless, very few allegations of sexual abuse move forward to prosecution. And in a study 30 years ago, this was looked at in terms of reliable accounts, recantations, unsubstained suspicions, insufficient information, and you can see that the fictitious reports are very low percentages. And it was for other reasons mainly that that the prosecution didn't go forward, not as a result of false allegations. And two psychiatrists, Green and Sketchy, and I use their observations a great deal in my own court expert testimony, they looked at children who gave false testimonies in comparison, usually encouraged by their parents, where in a custody dispute, the mother's claiming the child sexually abuses her, claims that the father is sexually abusing the child, and the mother then encourages the child to follow her story, her false allegation. And these two psychiatrists that studied children in that situation found behavioral aspects of their testimony to be quite easily distinguished from children who were truly abused. For example, the child who is truly abused will rarely confront the alleged offender, where the child is following the story of the separated and estranged mother, may well follow her story and accuse directly the offender in court. So even where there are false allegations, which are extremely rare from children, there are aspects of their behaviour that give away that they've been put up to this false allegation by a divorcing parent. So anyway, the message that I want you to take away today from my lecture is a very simple one, and I want you to use this message as a slogan for Smile as a Child. And the slogan is, false denials are common, false disclosures are rare. So that slogan can be used by Smile as a Child to advance that knowledge throughout Greek society. False denials are common from children, false allegations or false disclosures are rare. So what about the child in court? If the child gets to court, which is, as you just heard, extremely rare, if the child actually gets to court, there are even more barriers to convicting the offender. The child's testimony is acceptable to the court if the child is old enough to verbalise, knows what the truth is, and can distinguish right from wrong. That's most children over the age of 4. The reliability of the witness, though, is a little different. Children will often be inconsistent in the details of the abuse allegation. They'll be inconsistent in their past behaviour to the victim and in relation to the abuser. So the victim in relation to the abuser will have inconsistent behaviour. And there's usually an unreasonable delay because they've been anxious to tell anybody. And often there's no disclosure from the child at all. And the inconsistency from a child means it's a nightmare for lawyers. The lawyer, the prosecutor, the judge wants times, days, dates, specific details of the location, specific details of the abuse. The child who has suffered sexual abuse on more than one occasion, the abuse is a process, not an event. And the law, the court wants events. It can't deal with processes. It wants events. When did this event happen? The child cannot give that type of testimony because of the trauma it suffered from the abuse, and it's unreasonable to expect the child to do so. In terms of inconsistent behaviour, there's a very common defence mechanism that we use since we are babies. And according to Melanie Klein, this is called splitting. The good mother gives you the breast, the bad mother takes it away. And so you split your mother into the good mother and the bad mother, the nasty mother that takes the food away and the good mother that brings the food. This defense mechanism is used throughout life when you're confused about a person's behavior. The only way a child can be sexually abused all night and then sit there and have breakfast the next day with her abuser, and then go to the cinema with her abuser, and then be taken to school by her abuser, is to split that abuser into the good father or stepfather and the bad father or stepfather. The bad father is the one that comes at night, and the good father is the one that takes me to school the next day. Otherwise, the child would actually psychologically break down. So that defense mechanism protects the mind. And that's why behavior of children are inconsistent to their abusers. They will send them birthday cards, Christmas cards, saying, love you, at the same time as suffering abuse. And I've seen that presented in court by the defense lawyer saying, how can this child possibly have been abused by a stepfather? She sent him a birthday card saying she loves him very much, not understanding the psychology of defense mechanisms. The trauma suffered by children is both in childhood and in adulthood is immense, and the consequences of that trauma gets worse over time. So it becomes very difficult for victims to give clear evidence especially in historical cases of child sexual abuse. And the good father and the bad father being split over time means that they may find it difficult to bring testimony about that individual. When they give evidence, the child isn't in a neutral state. It's not there like a lawyer doing his job or a judge doing the job, although all of us can be influenced by an argument we may have had with our partner before we went to work, including judges and lawyers. However, the child is influenced by fear, by shame, by guilt. Have they done something wrong? By threats and inducements, not only from the offender, but from the offender's family and friends, as you heard. The family insisting that they recant their allegation because the dad will go to prison. And where are they going to get their money? Plus there's anxiety, stress, and stress of interviews. Now, I understand that in Greece, although you've passed some legislation, still the average number of interviews that a child has after they've disclosed is 14. That will just inhibit disclosure and promote inconsistent details. What you need to do is move to joint investigation procedures by police and social workers together, which is interviewed with video recordings of the interview. And those video recordings are the things that go to the prosecutor, go to the court, the child prosecution service, the police, to judge whether the case will go forward or not. It is wrong to keep interviewing the child by different professions because that constitutes secondary abuse. Children will often, when they are being abused, will often dissociate. Their mind will drift into some other aspect of their lives. They rather think about the sun, the beach, and swimming while their body is being assaulted. And of course, this is a technique used by prostitutes and by victims of torture to suffer what they are suffering. And that, again, is the way they can maintain an abusive relationship without going crazy. And that leads to the inconsistent details. Abuse is an event, not a process. Memories for one abusive incident will be mixed by others, and the details of one event will be confused, so that the child becomes easily confused when questioned by a lawyer. Recovered memories from the past are not clear or consistent. Victims say it's like a fog with different aspects of the abuse coming into your mind at different times. And memories are often recalled and mixed in with strong emotions, and if they're suffering post-traumatic stress disorder with flashbacks, that can create frozen behavior and distress. They feel trapped and helpless in their victimization, and self-blame is extremely common, such as the teenager that was 15 that went back with her boyfriend who was 17 for coffee, having no intention of having sex. But in the end, he raped her, and what she blames is herself for being stupid enough to go back to his place for coffee, not his behavior of rape. So the child's memory, in terms of the child's memory, they are as good as adults. We don't find any real discrepancies in children's memory other than when they're traumatized. Forgetting is often caused by children not understanding the event, and so it's not processed into long-term memory. So children under 5 that suffer sexual abuse, and there are paedophiles that target toddlers, the toddlers don't see it as sexual abuse. They perceive it more like physical abuse until they have become to learn about sex around age 7, and then they retrospectively become traumatized. And then 7 to 11 is the highest age group for straightforward disclosure, because they're a concrete operational thought. They think like children. Everybody's got to be given the same amount of ice cream. Everything has to be fair. And why am I being abused when other children aren't? And then when we get to adolescence, where we have formal operational thought like an adult, that's when the adolescents and the teenagers begin to project what will happen if I disclose. All these things will happen, and I don't want them to happen. They're not. And what happens in adolescent and teenagers is you get a drop off of the percentage that disclose because they begin to project what will happen as a result. So the most likely age group to disclose, although it's still only 1 in 10, is the 7 to 11-year-olds. Yeah. So a child's memory will be influenced, of course, by how it's interviewed. And we must use developmentally sensitive language. Now, I haven't got time today to go into this, and I'll talk more about this tomorrow in the workshop, about how you interview children to promote the highest chances of reliable information and disclosure. So I want to close on the necessity of child-friendly court practices. And again, I understand that you've developed legislation for this in Greece, but it hasn't been implemented. It's absolutely essential that when a child attends court, it appears friendly to them. That means they must have information about the court. What is a judge? What is their role? What is a prosecutor? What is a defense lawyer? And they need to understand what is going on. And of course, if it's terribly traditional, then it will look to the child as very fearful. When they're first interviewed following the disclosure, it should be in a child-friendly environment, what we call sexual assault referral centres in the UK, where rape victims, whether adult or children, and sexually abused children go to be interviewed and are videoed. Their rooms are like this. They look very like a home, rather than being interviewed in a police station or a hospital, or as a cold clinical environment, which will just close them down in terms of what they say. In addition, you've got to be careful about who you interview them with. If it's the daughter, and she knows that her mother loves her stepfather or father very much, and she's there being asked, what did the stepfather do to you? The daughter is going to minimize what happened in front of the mother. She's not going to talk about details of oral intercourse in front of her mother. So the evidence that is collected will be minimized as well, and therefore sometimes the prosecution won't go forward. So the child should not be interviewed with a close family member or friend. They should be interviewed with a trusted professional or a trusted social worker that the child has developed a relationship, a professional relationship, and they should be professionally supported in interviews, not in front of friends and neighbours. Now, these mechanisms, we've had a large EU project developing child-friendly practices such as video links, child's giving testimony through video or behind a screen in the court, etc. And we've gone in Eastern Europe, we've introduced these techniques through a Daphne project very successfully in places like Poland, Romania, etc. Again, Romania and Bulgaria have a similar approach to Greece, where they pass lots of laws, but somehow they don't get implemented. If you want to read further, there's a book that we've produced recently on assessments in forensic practice, so I'll leave it there. Thank you.